SJC-13198, the Haven Center, Inc., the Town of Bourne.
Okay, Attorney Zender.
Thank you, Madam Chief Justice, and good morning, Justices. My name is Ben Zender, and I'm here on behalf of Haven Center, Inc. The more I read this case, the simpler it gets to me.
Oh, good. Good. Do tell.
The question really is the general bylaw that the Town of Bourne passed a zoning bylaw? If it's a zoning bylaw, it has to have been passed, under the dictates of 48 Section 5, and it has to afford the landowners the protections that 48 Section 6 provide to an owner who submits an A&R plan to the planning board and the town clerk in advance of the bylaw.
And you're going to explain why this is a zoning bylaw.
I will. Thank you, Chief Justice. It's a zoning bylaw because it does nothing more and nothing less than regulate what you can do in a particular location in the town. And the pivotal case in this matter is Lovequist, because it's uncontested that if it's a zoning bylaw, it has to meet those requirements. Lovequist is the case that the town points to as authorizing a town to pass a regulation that regulates a particular use of land that's not a zoning bylaw. But Lovequist, in its sort of pivotal statement, and I brought one case up here with me just to look at, says that we're reluctant to classify the instant bylaw, in this case in Lovequist, it's a wetlands bylaw, as a zoning measure for the reason that Article 15 manifests neither the purpose nor the effects of a zoning regulation. The Dennis bylaw does not prohibit or permit any particular listed uses of land, or the construction of buildings, or the location of businesses or residences. The bylaw that Bourne passed doesn't attempt to regulate the use of marijuana in the town. It doesn't regulate any of the aspects. It's not a licensing bylaw. It's not a health bylaw. It doesn't say where you can operate. It just says you can't do it anywhere in the town. And for that reason, it really can't be interpreted as anything other than a zoning bylaw. Now, because...
I ask you, in your effort to simplify the case, can you also address what we do with the RACO decision then? Because RACO seems to suggest that one of the tests for whether or not something's a zoning bylaw as opposed to a general bylaw is the history of the treatment of such things.
Yeah, thank you, Justice Wendland. Yes, and I think the Justice hit it on the head. It's one of the tests, meaning both RACO and Spenlenhauer, which are really the two cases, in the Commonwealth, RACO being an SJC case and Spenlenhauer being an appeals court case, both point to the existence of a zoning regulation in town that attempts to regulate that particular subject matter. In Spenlenhauer, it was a parking ban. In RACO, it was licensing of mobile homes. But that was just one of the tests. In both of those cases, the court was clear to say that if they didn't make the finding that they found, then they would be derogating from the specific legislative intent of 48 Section 6, which is to provide particular protections to landowners so they could use and develop their land. So it's a test. And if we carry this through to its fullest, that would mean that if a town has not regulated something in the past, then they wouldn't be able to regulate something as a zoning bylaw. They could just pass a general bylaw. And that brings up the caution that RACO shows us, which is that the court cautioned that we have to be careful to attempt to regulate things as non-zoning bylaws. Because in RACO, the court suggested that somebody who didn't like an apartment use could somehow use a general bylaw to prevent that. So both of those courts, in both of those cases, use it as part of the test, but the underlying rationale is whether or not the implementation of the bylaw is inconsistent with the express legislative purpose in 40A, that businesses and landowners be given adequate protections for the use of their land.
I have a problem with making this simple if I look at 94G3A2. So 94G3A2 says basically that if a town voted no on the 2016 ballot on the question to limit, they can then pass a town bylaw doing this. Isn't that right on point here? That we have a town that voted no in the ballot question, and therefore they have this right through a town bylaw to do exactly this, which is prevent this from happening. So why isn't that the simple way of handling the case?
Thank you, Justice Coffer. Yeah. Well, and I think I agree with the town in this respect. A town has an absolute right to pass a zoning bylaw to prohibit marijuana within the confines of the town. And 94G 3A2 sets forth the way that you do that.
I thought, but I thought 94G 3A2 draws a distinction, or at least the CCC's interpretation of it draws a distinction between zoning stuff and town bylaw stuff. And
It does.
And they're saying that you can do exactly what the town did here, which is, because it's a different process, it's the whole town government voting it, right?
Except, in order to read 3A2, you have to go back and read 3A1, because 3A1 says that no regulation, it says no zoning regulation shall operate to prevent the conversion of a medical marijuana treatment center or to limit the number of licenses below the number set forth in 3A2.
Well, but don't they distinguish that because it says no zoning, right?
The only, well, I know the courts have looked at 94G Section 3. The only place in that statute the word zoning appears is 94G 3A1, where it says, essentially, a town has the right to pass reasonable regulations of marijuana, except that no zoning regulation shall be used to prevent the conversion of a medical marijuana treatment center or to limit the number of licenses below the number in 3A2. And then 3A2 sets forth the procedure for how you do limit that number of licenses by saying, look, if the town voted no, then it can go right to a town meeting. It can pass a town meeting prohibition prior to 2019. If a town voted yes, it can go to town meeting, but it also has to go to the ballot. So
But I guess, I don't really understand how that is helpful to your client, because it sounds like the legislature understood in 3A1 the use of the word zoning and used it when it wanted to use the word zoning. But then in 3A2, it doesn't use the word zoning. And usually, as you know, the canon of construction is that if the legislature meant to limit towns to zoning bylaws, they could have said so, as they did in 3A1.
Thank you, Justice Wentworth. I think in a reading of the statute, 3A1 says what you can and can't do. 3A2 says how you do it, meaning it says in 3A1 you can pass reasonable regulations, no zoning bylaw shall be used to prevent conversion or limit the number of licenses, and that except as set forth in 3A2, and then 3A2 sets forth that particular procedure, which I might add, is designed to facilitate the activities of adult use marijuana in the Commonwealth. The entire statute, as this court recognized in Comcan, is designed to facilitate. And as this court said in Comcan, it was specifically designed to facilitate the conversion of medical marijuana treatment centers to adult use centers. So the first section says what you can and can't do. 3A2 actually provides a facilitatory mechanism by saying, look, if you voted yes on marijuana, you can't just go right to town meeting. You have to go through a ballot procedure as well. So 3A2 limits the ability of a town to prohibit marijuana.
And so
Except,
just-
I'm sorry, go ahead, Chief.
So what did they do wrong? Tell us how they
Here's
did it
what they
wrong.
did wrong. What the town did wrong was, and understanding the town had already passed a marijuana health regulation. They had already used 94G section 1 to pass a health bylaw which regulated the health aspects of marijuana in the town. As the court could see from the record and from the briefs, there was essentially a range war going on in the town of Bourne as to whether or not marijuana would be allowed. There was a moratorium. There were 2 articles to ban general and both general and zoning, which were defeated. Then there was a petitioned article to defeat it, which was passed by roughly a 56% margin. Then there was a town-sponsored article to regulate it, which was defeated. There was never really the quorum to pass a zoning bylaw. So what the opposition did was they passed it as a general bylaw. Now, it's antithetical to the statute itself. If the statute says that no zoning bylaw shall operate to prohibit conversion of a medical marijuana treatment center, or a licensee, I'm sorry, to adult use, why would the statute allow a town to use a lower quorum of vote under a general bylaw to affect the same purpose? It's inconsistent with the purpose. What the town should have done.
But by the way, isn't that the way the CCC actually interprets that?
It's hard. When you look at the CCC regulations, what they really do is they really just restate the statute. They don't, in my reading, they don't dig into.
I was just looking at the record on 488 and 489 where we go through what the CCC says. You cannot prohibit conversion from medical and they talk about zoning bylaws. But then in the next page, they say, you know, you can do this through a town bylaw, it looks like. I mean, I understand, it's not the clearest thing on earth. Yeah.
I have to say, by way of personal comment, I think 94G Section 3 is not a well-written bylaw. I have read it a number of times, and every time I read it, I have to learn it all over again. What the CCC does is they just restate the statutory statement that says a town bylaw. It doesn't differentiate between zoning and regular bylaws for the purposes of that.
They do, if you read their sentence, it goes, if a municipality voted no on the initiative, then the governing body may limit or ban the number by passing a bylaw or ordinance, which is different than on the previous page where they talk about zoning bylaws or ordinances are not permitted to operate. So I mean, either they're being careful or dense.
I have two comments on that. First of all, and I'd like to answer your question and pivot to something else by using what Justice Coffey just brought up. First of all, it's a statement put out by a regulatory agency of their interpretation of the law. I'm not sure they were looking at this particular issue when they did that, but it's a statement of a regulatory agency, which I don't think is binding. So I don't think that really can educate this court in any meaningful way. I don't think it does. So, and thank you, Your Honor. My second point is lost on me now, so I'll answer any further questions the court may have. So to go on, if the court were to allow this bylaw to stand as a zoning bylaw, then what the court's doing is it's opening up, as Rayco put out, it's opening up the specter that any use that somebody doesn't want in a town can be prohibited in a summary fashion by the adoption of a general bylaw. And looking at the record in this case, it's pretty clear what the applicant did. And what the applicant did here was came into town, received letters of support from medical from the Board of Selectmen, signed an option to leased the property, began the licensing process, received their medical licenses, literally invested, and the record supports this, millions of dollars to have a general bylaw come in place to shut it down. And that's exactly what the legislative intent of Section 48, Section 6 is intended to prevent. It's intended to prevent this taking away of the rights of businessmen and landowners.
Is your client really, because your client got permission to do a medical marijuana store, and so the expectation is not necessarily they're going to be able to convert it at the time they begin this process, right? It's a little different than if, you know, there's a zoning regulation passed, you know, and your client has been given permission to do a commercial establishment, right? It's a little different, right? The expectations are different.
It is, and as the court may be aware, you know, because of the way that marijuana was rolled out in the Commonwealth, you know, medical treatment centers were authorized first by statute, and the companies came in and developed these strategies and the process of creating these treatment centers. And then when adult use was enabled by the legislature, adult use became a much simpler and much more profitable way to operate in the Commonwealth. And that's why the treatment centers are really not that common. And so what the applicant did, understanding the change in the law, and as this court has held, is completely permissible, you know, filed an approval not required plan with the town to protect the ability to have that use in the town. And this court has held that the simple filing of an A&R plan, approval not required plan, for the express purpose of protecting those 48 Section 6 rights is a permissible use of the plan process. And so although Justice Coffey is right, the applicant came in and first got that license, 94G Section 3 specifically states you can convert, and they protected that right by filing that A&R plan. And so if I had to leave the court with one idea, this petitioned article by the town is really an end run around zoning. And there's nothing in 94G Section 3 that evidences any legislative intent to abrogate 48 Section 6 with regard to with respect to adult uses. And if the legislature wanted to make adult use marijuana something that wasn't able to have those protections of 48 Section 6, they would have put it in the statute. And finally, again, reading this statute, as the court recognized in CompCam, this is not a prohibitory statute. It's a permissive statute. And I think the court has to read the statute in that way. And thank you.
All set? Okay, thank you.
Thank you all.
Okay, we're ready, Attorney Troy.
Chief Justice Budd and justices of the Supreme Judicial Court, My name is Robert Troy, and I represent the town of Bourne and the Select Board. There are at least two universes of regulation, and it's fair to say that my brother is arguing one universe and I'm on a different universe, because I suggest that this case is not about zoning at all, but instead a question of whether or not one of the non-zoning regulatory mechanisms, which is described in a treatise that I've cited in my brief, can be utilized. So I think the town would have 3 points to make with respect to this question. The first is the general bylaw a valid municipal enactment pursuant to 94G, Chapter 40, Section 21(1), and the Home Rule Amendment? As these statutes were analyzed in very, very important decisions issued by this court on August 30th, and even though those two decisions dealt with zoning bylaws, the language in those decisions is critical in interpreting the scope of non-zoning mechanisms with respect to deferring to the legislature the decision as to what is correct public policy, but more importantly, in paying attention to the legislative words as a window to understand the intent of the legislature. So I would...
Do you have an example case regulation anywhere where a use is prohibited by a general bylaw?
I do not, but I would suggest, Your
So
Honor...
isn't that an indication that maybe only a zoning bylaw can prohibit a use?
It may be correct that only a zoning bylaw can prohibit a use. However, there is no use prohibited under the general bylaw. If you look at the general bylaw, it has none of the earmarks of a zoning regulation. It has no zoning districts. It does not change any of the uses. It does not change the zoning map. The use which the Haven Center says that it qualifies under a retail use is unchanged. And so I think if you look at the statute, the intent of the statute, which I respectfully disagree with my brother, I think it's a very complicated statute, but I think it's a very carefully written statute. And I think the language in the cases that I referred to, in the Comcam case in particular, suggest that we have to look at the language that is used by the legislature. And when used in one portion of the statute and not used on the other portions of the statute.
But counsel, if you can't give me one example of the use of a general bylaw to prohibit a use, doesn't that indicate that when 94G Section 3A2 says you can prohibit this through a bylaw, that it inherently means a zoning bylaw?
Well, I think that the statute says that a zoning bylaw, the one time, as my brother has pointed out, that is utilized, a zoning bylaw cannot prevent the conversion of a medical marijuana facility to a recreational or other type of facility under the statute. I think what that's saying is that in that particular instance, unless you have a zoning bylaw, it is by use of that term, it permits and authorizes a general bylaw. And I believe the reason for that, and I refer to the caloric case, which this court decided and is on cited on page 47 of my brief, gave me a window to understand that what the issue here is actually vested rights. So let me use this case as an example of why the legislature would say that you can only prohibit something through zoning and allow it to be allowed as a general bylaw. And that's, in this case, at the special town meeting, there were two efforts. One was to pass a zoning enactment, the other was to pass a general bylaw. My brother's client filed an A&R plan 6 days before the meeting, which would have, had the zoning bylaw passed, given him the protection, the use protection that we referred to. At the time, no one knew what the town meeting was going to do, and it was, as my brother has said, it was a spirited battle, which came up repeatedly, but ultimately, the town meeting decided to pass a general bylaw.
Can I just probe that, because I don't get it yet, because the 94G says you can't use zoning to prevent conversion. You've got to allow conversion, right? Why? What is the difference between doing it through zoning and doing it through a general bylaw that says you can do it the other way? Is it because it's a better reflection of the town's intent? I just don't understand it. Why would one be allowed and not the other?
It's because of vested rights, because
What does
if
that
the
mean?
idea that the legislature had was to give communities the local option to ban recreational marijuana, that option would be defeated if it were done under zoning, because you could do just as my brother's client did. Any number of people could file through zoning protection, which would defeat the purpose of the local bylaw. In other words, the local option
Can I
is.
push you on that? Because how is a practical matter that going to work? If the town has, again, we're dealing with the town having voted no on recreational marijuana, right? How would someone have had a vested right how would someone be grandfathered with a right to convert? I'm confused by that.
If it's a zoning bylaw and you file an A&R plan,
Yeah.
as of the date of the filing of the plan, if it is approved, it is passed. So 6 days beforehand, in this case, my brother's client filed an A&R plan. If the zoning bylaw were passed by the town meeting instead of the general bylaw,
Right.
he would have the right to have a marijuana facility, a recreational marijuana facility, because he had protected his right under zoning. That would defeat what the town voters wanted to do.
Even though it was a moratorium under zoning at the time that said you couldn't, we're not going to decide the recreational marijuana.
Yes.
By filing an A&R, he could preserve the right to do, he would have the right to do that unilaterally?
Yes, Your Honor. And if that were
Can you
done.
tell me, is there a case that says that, that I should look at? Because that confuses me a little bit.
There are cases under Chapter 4181P. I don't have that right here.
So the cases where something isn't legal yet, where you file an A&R, I mean, again, we're not dealing with something that's permissible under the zoning laws and you filed an A&R. We're dealing with something that isn't permitted at the time. And then you file an A&R and that gives you the right to do it? I'm not a zoning lawyer, but that seems odd.
I understand, Your Honor. At the time that the A&R was filed, there were no zoning prohibitions
But there were no
against recreational marijuana, and therefore.
But there was a temporary moratorium preventing it.
But the moratorium was about to expire, and that would not, the moratorium would not interfere with the statutory protection given the use that was grandfathered as of the date of the filing of the plan. And so where the problem is that would then defeat the legislature's goal of giving communities local options. And this is exactly what, if you look at what this court said in the Glure case, it talked about moratoriums, exactly that issue. And it talked about there's a concern that they give, I can't quote the exact word, but something that they presented opportunities for unwise exploitation, which the zoning bylaw amendment would prevent. And so what we are suggesting, Your Honor, is that the legislature was very aware of the distinction. They wanted to guarantee a local option, and they understood that if they allowed zoning to with its vested rights to trump that, therefore the whole statutory scheme would not work. And for that reason, the legislature determined and decided. And I think that the language in both the West Street case and the Comcant case, if you look at those decisions very carefully, and I think very rightly, both summarizes the scope of the Home Rule Amendment, but it also it focuses on the broad scope that goes back to, I believe it was 1692. for
Counsel,
chapter
could I just
40.
ask a question about the difference between the two? You said both of those options, the town bylaw and the zoning bylaw, were on the table at the time of the town meeting.
Correct.
Is there some difference procedurally to getting one enacted versus the other than just the meeting of at the town meeting?
No, the only difference is that the quantum of vote is different, and there are procedural prerequisites for zoning enactment that do not apply to a general bylaw.
So general bylaw,
is
you
easier.
just has, you just need 51% of the vote, whereas
Correct.
a zoning bylaw, you need 2/3.
Correct. And those are all legislative determinations that the legislature could change at any time, but has not. I think the important thing that the town would respectfully like to focus on is the language in the two decisions that the court issued at the end of August that talk about the scope of non-zoning regulation and how that has been both.
No, I get that. I just want to make sure, in the record, because I haven't dug deeply into it, but is there a transcript of the town meeting?
No, there is not, Your Honor.
Okay. The fact that the applicant had filed the A&R 6 days before, and the consequential effect of that, was that discussed at the town meeting?
I do not believe it was, Your Honor. As a matter of fact, I don't even believe that the town meeting was aware of that. I think what as a matter of fact, at the town meeting, the planning board spoke in favor of an adoption of a zoning bylaw, and quite frankly, so did I when I was called to the podium. But the town meeting had a will of its own, and I suggest that whether or not anyone agrees with its will, as a matter of law, unless you honor their decision here, you are closing the door on the ability of municipalities to use the Home Rule Amendment and the municipal police power to regulate subjects other than marijuana. This is it happens to be talking about the marijuana statute, but if you look at the two decisions that the court, and particularly the very, very succinct discussion about the Home Rule Amendment that was in the West Street Associates case, I think that is the issue that the court might want to focus on, because that is going to be an important tool. As a matter of fact, the section of Bobrowski, which I cited in my brief, talks about the many, many areas of non-zoning regulation. And finally, I want to point out that what this is very similar to is the regulation of alcohol that was adopted by statute immediately upon the end of Prohibition. And that statute has a striking similarity to the marijuana statute, in which the state said, we want to give cities and towns the option to regulate these questions by a vote of the voters, and that's how it is done.
If we can tell anything from the requirements of what it takes to pass zoning as opposed to the bylaw, because we have two issues going on in this case that are reflected in the statutes. One is that we want to be able to have, if you have medical marijuana, we want to be able to have an easy conversion. But the other issue we have going on is if you voted no in the referendum, you have an opportunity to say no to marijuana in your town. Is there anything about what it takes to pass a zoning ordinance or a bylaw that reflects what the outcome should be?
Well, I think you could do it under either way, Your Honor, but in this situation, I think we should focus, or I suggest that we should focus on the ability of the town to use the general bylaw to do that. And on that point, I would add, if you look at the statement of undisputed facts, which are on page 777 of the transcripts. Undisputed facts 31 through 35, I suggest, foreclose the opportunity for the appellant here to suggest that this is a zoning regulation, because those undisputed facts which he agreed to and the client agreed to clearly indicate that the town of Bourne had no history of regulation by zoning of this subject.